Gunn versus Wallsend, Slipway and Engineering. This case is all about a wife dying of an asbestos-related disease. Does the claimant win this case? Let's find out. Facts. Between 1948 and 1965, the claimant's clothes were embedded with asbestos dust. The wife of the claimant would shake the clothes before washing them in a tub. She did this until 1960. She then died of mesothelioma in 1986. Issue: did the employer owe Mrs. Gunn a duty of care? Was it reasonably foreseeable to the defendant that by Mrs. Gunn shaking and washing her husband's clothes that she would have contracted mesothelioma? Held. No duty was owed. The claimant unfortunately was unsuccessful in his claim for damages against the defendant employer. Now let's find out the reasons why. Number 1. Before 1965, no employer would have foreseen risk of asbestos exposure by shaking clothes. Number 2. There was no publication or warnings. Number 3. Even if the employer had the safety measures in place, it would be unlikely to foresee domestic exposure would lead to illness. Now let's distinguish this case with Margerson. Here, Emma Child played in a loading bay contaminated with asbestos. The claimants here were successful in their claim for damages when the child suffered mesothelioma. A duty was actually owed. So why was this different? Let's find out. Answer: here it was reasonably foreseeable that there would be a risk to injury, not necessarily mesothelioma. Literature did exist at the time, children here were treated as employees, and most importantly, the defendant were aware of the risks and actually failed to remove the asbestos.